The judge in Stormy Daniels' theft case against Michael Avenatti has twice warned jurors that if they lie on their juror questionnaires, they could be charged with perjury. This comes after not being truthful on other juror questionnaires has made headlines. There's the Ghislaine Maxwell juror who allegedly lied about being a victim of sexual abuse and then shared his experience as a victim during the deliberations. In Ahmaud Arbery's death, there were 1,000 notices sent out to potential jurors, and days were spent questioning those jurors to pick a jury. Still with us, because there's a lot to talk about on this topic, Wendy Patrick and David Bruno. Thank you for staying with me. Our guest legal analysts, both well-versed, well-seasoned attorneys. The first question that comes up for me is whether or not you're under oath. So, David, can you be charged with perjury if you're not under oath when you make a statement?
Yeah, I agree with you. And in fact, I just asked the producer prior to this segment if that's the case, because it's odd to me. I mean, in my state, look, we do not certify to those answers, and the judge does not put potential jurors under oath. I again just asked the same question. I mean, is the judge going to put these prospective jurors under oath? Because there will have to be some violation of an oath to come to a perjury charge. I think in the end, there's strong public policy to hold the jurors to truth when answering those questions. It's the foundation of our entire criminal justice system that we're going to get unbiased, objective jurors that are going to listen to the evidence and make their decision based on the evidence alone and the law that's instructed. And look, we've seen this multiple times recently on some of these big cases, including the Maxwell case that we're talking about now, which is, wow, that juror was not truthful. I could see the public policy behind it, but I wonder, in the event that there's actual charges lodged, and by the way, I mean, a prosecutor will have to lodge those charges and present those charges and prove those charges. But if I were a defense attorney representing a prospective juror that's facing allegations of perjury, I'd be standing up there and saying the same thing, Ashley. This individual was not under oath.
And as a former judge, I have to tell you what I think I would do is I would then do a nuts and bolts process procedure to ensure that if perjury is something I as a judge felt like was necessary to threaten, quite frankly, to get jurors to respond truthfully to the questionnaire, then you have to take that into account and put them under oath. So I want to give a few more details that I happen to know about this particular judge in the Avenatti case, because what he did is interesting to me. He actually did tell them, if you don't answer truthfully, you'll face perjury. He also had the attorneys, he left the courtroom, he allowed the attorneys to tell them about the case a little bit before they answered the questionnaire. And to your point, David, he put them all under oath before any of that happened. So yes, in this specific federal trial, they're under oath, they're told something about the case, and then they are told to fill out that questionnaire truthfully. But I think, Wendy, that's a little bit different than a Ghislaine Maxwell, where they have a jury questionnaire perhaps sent to them in the mail that they fill out before they come to court. It may not be under oath, and then they come to court and they're questioned by attorneys. In that instance, it feels like it might be a little bit easier for a potential juror to not be as focused on, I better make sure I read everything well and give all of the truthful answers because I'm under oath.
Ashley, I can't tell you how many cases I've had to try more than once because of jury misconduct, consisting specifically of somebody not revealing in voir dire that they were sexually abused and then bringing it up for the first time in the deliberation room to influence other jurors, or maybe not to influence other jurors, just to help them understand, which of course we don't want to have happen. But there's a big difference between intentionally lying either in court or on a questionnaire and basically honestly believing the question doesn't apply to you. I mean, think about it. It's like if you ask a juror if they have bumper stickers on their car and they don't because those were on their last car, which they sold last week, they can get out of answering that question. So too, if questions are not artfully phrased. Many jurors are asked about being a victim of a crime, but nobody was ever charged with anything, so that's not the way they remember the incident. So there are lots of ways in which lawyers and judges have to be very specific in the way we ask our questions so we don't honestly have jurors believe the question doesn't apply to them. Many people don't want to give this information. They're private. This is personal. It's painful. It's traumatic. They don't want to relive it. Let's not give them a reason to believe honestly that those questions don't apply to them.
And it's really hard, I think, too, with jurors, when you're talking to them and asking them questions. The whole point of a jury questionnaire, at least part of the point, is to shorten the amount of time necessary to pick a jury. And then you're not, therefore, often by judges, myself being a former judge, to question them for a long period of time. So each of these pieces is a crucial piece to selecting a jury that is going to be unbiased and reaching their conviction or acquittal, whichever they do. All right, stay with us. Coming up, 90 Day.